Thank you, everybody, for attending. I appreciate the opportunity to share the next hour with you. We are promising to have a lively conversation, which is always comical because Matt, Diana, Dennis, and myself typically huddle, somewhere along the week and have a conversation of, well, what do you want to talk about? Like, gosh, I don't know. We haven't had a lot of changes. And then within the last 72 hours, it seems like there's just been a barrage of information that's come towards us. So we appreciate that. Diana is going to kick it off and just do some quick HR updates, which is going to be on Family First, Social Security. We have a special guest today, David from Paylocity, because we thought it would be a nice opportunity to kind of get the Social Security executive order deferral options from a payroll company's perspective to see what they've been experiencing as well. And then Matt will be sharing with us a litany of information. I will let you know that we don't have a lot of slides on him, so we can showcase him. And the reason is because I think yesterday at this time, Matt was on a beach sunning himself and just drove in, I think last night, if I remember correctly.
That is correct. So I'm super fresh. Yeah.
And as the conversation goes, certainly send emails, info@Arcwood for questions. I've got that open and populated. Certainly the chat box is going to be up and running and populated. So any means that you feel comfortable submitting a question to us, certainly feel free to do so. And then probably just my last course is to make sure I read our disclosure. For all of you compliance nuts out there like ourselves. So just for quick disclosure, Arcwood Financial LLC, Arcwood Benefits Consulting Inc., and Arcwood HR LLC, as you guys know us as Arcwood. We are all independent companies of which we do not offer legal or tax advice. Our goal is to provide information to you for assisting in making the decisions at your company with your leadership teams. But we will leave the legal and the tax work up to those professionals, which is why we such enjoy having the relationship with Wellman as well as with Dennis Hall. So with this, I think, Diana, I will turn it over to you and we can explore any changes that we've had from your aspect.
Because there's been no changes whatsoever, none ever, no. So,
and I put Dennis on this screen too, so
just in case,
if Dennis signs in,
on,
we can loop him in as well.
Okay, perfect. So yeah, it's been an interesting 72 hours because that's basically when a lot of this stuff has kind of come through and questions have come in with regards to some of these things and trying to make sure that we have everything covered the way we need to have it covered. So first we're going to go over some updates to the FFCRA, which is the Paid Sick Leave and the Paid Family Medical Leave Act that was effective on April 1st. So if I can have my first slide. So the DOL recently has added 3 additional new questions to their FAQs. And all of this is in regards to now that school is either in session or looking to go into session soon, depending on where we're at in the country. They have provided employees and employers some additional language around how to manage the FFCRA leave for this. So question 98 is about a child attending school on a hybrid or an alternating school schedule. And employees are eligible to take the paid FFCRA leave. And this is both the sick leave, because the first 2 weeks of the 12-week medical family leave is covered under that time, and or the 12 weeks of paid leave is all under this. So they are eligible to take the time off for those days that their child is not in school, and they either have to be on remote learning, or if they are allowed to go to, they're in the school Monday, Wednesday, Friday, but they have to be home on Tuesday, Thursdays. An employee can take those Tuesday, Thursdays off if they need to be able to care for the child if there's no one else available to take care of their child. But if a parent chooses, if the school gives you a choice of we're going to in-person learning 5 days a week, and a parent chooses to continue the remote learning, then they are not eligible for the paid leave, because the reasons under FFCRA is only if the school is closed or the child care facility is closed. That is why an employee would be eligible. So under question 99 on the FAQs, that's you're not allowed to make that choice on your own. It's only if the school is making that choice for you if they are closed or not. And then the next slide shows question 100, which is about school is starting under a remote learning program and will continue to evaluate depending on local circumstances to determine when our in-person learning will start. Am I eligible? And yes, that again shows that the school is closed. Once the school is determined, like here in Arizona, I believe a lot of kids are going back in person this week, that we've met our numbers. And so we were in remote learning before, so they were eligible for it then. And now this week when kids are going to school in person, then they would not be eligible beyond that to take the FFCRA leave. But with the note under that and with the guidelines and the information that we're seeing is that while an employee may not be eligible for the FFCRA leave, you know, if a school is technically opened or if there's in-person working, an employer should maybe look at, and this is where that whole, you know, consideration and making sure that we're taking care of our employees. Let's figure out, is there a different way? Are there other options for an employee during this time? Because, you know, a cost of a replacing employee can be anywhere between 20 and 200% of a yearly salary of that employee. So are there ways that we can do a flexible schedule, figure out a job sharing program or a split schedules where they work in the morning, they take their afternoon off and then work in the evenings? Is there ways that we can manage the schedule so that an employee can take care of their job and then also take care of their children during all of this crazy remote learning and time of all of us trying to figure that out? I've seen pictures of parents posting of their, kids just flopping down because they're just so tired of doing remote learning and they don't want to do it anymore. Or, PE class through a Zoom just doesn't seem to be the same. So let's find ways to be flexible and considerate for our employees with regards to this time and taking time off.
Diana, do you have, so we have direct clients that are using these flexible work schedules and these hours. Are they being successful with it? Are they finding that there's additional challenges just from a leadership perspective as far as, making sure everyone's on track of what's happening and controlling the workflows? I
haven't seen anyone specifically, though I know even in my own personal case with Cass, we've done a flexible kind of schedule where, she's based on what's going on. She may need to go in the afternoons and deal with childcare and manage that. And then she gets back on in the evenings after the kids have gone to bed. So you find ways and you work with your employees directly in making it work. Because I know that at least we've been able to in our situation make it work.
Great. Thank you.
Next slide. So back in early August and before, there was a court case against the DOL in the state of New York, and the court gave its decision on August 3rd, and on late Friday, the DOL made some revisions to their FAQs in conjunction with those decisions, and they have chosen to take the decisions by the court and rework the FAQs to fall in line with most of what the court said. And there were 4 major areas that were tied to that lawsuit, and they have made it nationwide compliance. So they're not just doing this for the state of New York, which some thought might be the case. So the first one was regarding being able to use the FFCRA leave only if there was work available. And so the court said, you know, if they're an employee, doesn't matter if there was work or not. This is the one that the DOL said, well, no, that's not how the regulations were actually, the law was actually written. So they are sticking to their guns on this one with regards to that FFCRA leave is only available if the employer has work for the employee. So if an employee has been laid off or furloughed or a business closed, then the employee is not eligible for FFCRA, but they may be eligible for unemployment benefits. And so that's how they took that designation and how they see the separation on those two. The next big one was about intermittent leave. And the court said you can't, you know, an employee should be allowed to take time off intermittently, but if it's in a full day access only. So, and only if it's for childcare and if it's only for worksite work. So if someone is telecommuting and they want to do an intermittent work day because they are sick or they're caring for someone, but they can work a couple of hours but need a couple of hours off, if the employer agrees, then that's allowed. If it's for a full day, so like our hybrid schedule, school is in session Monday, Wednesday, Friday, then the employee is allowed to take their FFCRA leave on that Tuesday, Thursdays when their child is not in school, and that is allowed. They don't have to get an employer's approval because that's not considered intermittent. So it's only that partial day leave that is now considered intermittent. And it's only for those employees that are working on site, not just the telecommuting. And it's only, intermittent is only covered under the child care. So if someone is sick and they're a worksite employee, there is no intermittent leave allowed. The third piece of the court case was about the healthcare provider definition. Initially, the DOL said it didn't matter what role you had in a hospital or a school or location that was considered a healthcare facility, everyone was exempt. The court case said, no, that's not the way this should be working. Employees that are not, so a healthcare provider is only those that are providing diagnostic, preventative, treatment, or other services that are integrated with and necessary to the provisions of patient care. So the front desk clerk is not considered a healthcare provider, and so they are eligible for the FFCRA. The doctor in the office is not eligible for the FFCRA under the new guidelines and provisions. And then the last piece on this was the clarification on the information required from an employee. So the way the DOL originally had written this was that an employee had to provide all of the documentation requested from the employer before the leave could be approved. The court case said, nope, they may not be able to give you that information, so they have to be able to provide it as soon as practical. So if they can't provide the information before the leave is actually needed, we are, as employers, required to give them that time to get us that information. Now, it's not forever. There is some guidelines within the FAQs that it has to be within a day or two after they start their leave. So if they're sick, a day or two after, they have to be able to provide you with the information. But they also, at the end of the DOL FAQs, they say, again, encouraging the collaboration between the employee and the employer of making sure that employees are able to take their leave when they can, they're not coming in sick. So working with your employees, both not just for caring for themselves or others if they're sick, but also through the childcare stuff. So continuing to work with our employees through all of this process. But then the fun came up. So this came up, I was reading an article, and so under the FFCRA, individuals are given the 80 hours of FFCRA paid sick leave to use between April 1st and December 31st. And those 80 hours are tied to an individual, not to the employer. So if I am an employee and I work at company XYZ and I took my 80 hours of sick in April and I have now quit and I am now going to go work for the Acme company, I am not eligible for an additional 80 hours of FFCRA leave just because I'm at a new employer. I've used and exhausted my whole time. So how are employers supposed to manage this? Good question. And this has been a flurry of discussion, as Pete can help me attest to today,
Yes.
in trying to figure out how to manage this situation, because we're guessing a couple of things came up over the weekend with regards to this, and today, that this is going to be a new thing probably as employers are starting to open back up. Employees may have gone and worked somewhere else. Now they're working, that business is closed. They're going to go work somewhere else. And how to manage through this. There is, at least from what I've been able to find, nothing in the IRS or the DOL guidelines that talk to this specifically. So there's a couple things that employers should be doing to help protect themselves. One is make sure that we're documenting the requests that we are receiving from our employers. That we're keeping the information, the requests that we're getting from our employees, that we either are having them fill out a document or that we're keeping a spreadsheet of all of the employees that have taken leave and the reasons why. But as new employees come in, it's been recommended that we have an employee sign a document that states that asks and states that they have or have not used their 80 hours of FFCRA paid sick leave. And if they have, they understand that they're not eligible. And if they lie, there could be consequences up to and including termination for lying around their usage. Pete, you want to jump in?
Well, I think it's, so there's obviously volumes of information here. And so really kind of taking a step back, what we're talking about is that when the 80 hours are being funded, is being funded by a payroll tax credit. So from an employer's perspective, when I'm accepting the 80 hours that are going out to to the participants or the employees that are requesting this, then I'm certainly going to be requesting that on my 941s, which are the quarterly ones, if I remember correctly. I got a payroll guy and an HR person on the phone, so I can probably get that clarified if I need to. However, as an employer, how do I know if that new hire that I hired maybe when I'm reopening in September, have they already taken that 80 hours? If they have, and I don't know about that, then what's at risk is my credit, because I could potentially get a notice from the service saying that that individual, when they're reconciling Social Security numbers, has already received that 80 hours from a prior employer. So therefore, I'm going to be denied that credit. And if you kind of think how, going back to everything that has kind of domino effect from this national emergency to the point where we don't, we have a coin shortage because of the furloughs at the Treasury, and we've got, meat shortages, and there's all sorts of shortages that are obviously happening. Well, the IRS is experiencing the same thing. So when we're submitting these quarterly reports, when are they going to reconcile that? I mean, it could be 24 months down the line before we get a credit back. And depending upon the size of the employer, a large employer can say, okay, well, we can absorb that. But from a smaller employer perspective, that could be, detrimental to the cash flow. And so we made some phone calls this morning to some attorneys, and they really asked the question is, we have some concerns about privacy. What are some of the latitude that we can be granted so that when we're interviewing somebody, especially that's coming on mid-year, what is our protocol? Can we have them sign off on something? And the answer was yes, you may. Because, if you're thinking about the spirit of the legislation and also in the spirit of helping employers, because remember, a lot of the stuff that's happened through the CARES Act has been trying to get money into the employees, but through the avenue of the employer. They need us as, kind of a conduit system. So they're creating systems around that. But yes, we may ask new hires, have you received any hours, and have them document and sign off on it. Purely to, protect us from, making sure that we have the appropriate credits that we can expect through Social Security. Fair? Is that a good summary?
Yes. It's been a lot of information to digest very quickly. And so but it was something that came up on our radar this weekend, and we wanted to make sure that employers were at least, and our clients were aware to
Right.
start thinking about this. We just don't know what the risk is at this point. So we each have to make that determination.
Right, especially with a reopen versus potentially another close, more furlough. We could live exactly what we lived to the second quarter. We could experience that again in the fourth quarter. We don't have that information to make these decisions. And anybody that's had a conversation with me, I'm always,
I'll take a couple.
constantly banging the drum to make sure that
I'll walk over there. Okay.
hang on. That we're constantly, I just mute everybody. So Diana, if you want to say anything, you got to come back on.
Got it.
So I was saying, we're always hammering on the fact that we have to have information to make decisions. And it's hard to make these decisions without having this information readily available. So I think it's prudent for us as employers, if we're bringing people on within the next, 4 months, 3 months left of the year, that this is something that is fair to ask, just to make sure that we're protecting ourselves as an employer as well as the employee.
Correct. And I just got a question with regards to the calculation of the 80 hours. And so an employee could be working multiple part-time jobs, and so they could be also getting 20 hours at company A and 20 hours at company B and 20 hours at company C, and then 20 hours somewhere else, but they still can only have up to the 80 hours. So we may only, as an employer, be responsible for 20 of that 80 if they're a part-time employee, but we still have to take that into account, because they could be full-time somewhere else and working 80 hours in one location and 20 hours a week somewhere else, and could still overhit that 80 hours. And so it's this gray area of the rules, and the laws didn't give us anything on how to manage this. And so it's one of these gray areas that we'll continue to probably run into as we go through this process.
Yeah, well, it's going to take
figure out how to manage it.
Yeah, it's going to take employers sitting down with pen and paper and mapping it out. If they know that they have employees that are working at multiple organizations and subject to the hours, and so there's definitely could potentially be some work involved, unfortunately. So you want to go on to the next exciting topic?
Let's go on to the next exciting topic, which is the Social Security deferral. So that went into effect. So on August 8th, our president signed Executive Order Notice 2020-65, saying that employers could defer, or employees could defer the 6.2% Social Security tax on their checks starting on September 1st through the end of the year. And all employees that had a biweekly compensation of less than $4,000 were eligible to participate. However, the deferrals will have to be paid back. So while employees may see a bump in their checks through the end of the year, they would have a lower check starting at the beginning of the new year to pay those deferrals back. So this was signed on August 8th, the Treasury and IRS finally gave us some guidelines on August 28th, like the day before, late Friday, before this was eligible and starting to go. So employers and payroll companies have been scrambling to try to figure out how to make this work. And one of the things that the guidance gave us was that the deferral was not mandatory. So employers didn't have to participate in this. An employer can choose to either opt in or opt out. An employee cannot force the employer to comply with this because they want to participate. But if an employer does choose to opt into this program, an employee does have the option to opt out and not participate in the deferral. But some of the kind of open questions with all of this is, one, will the government make a decision to waive the payback of the deferral? We don't know that yet. We probably won't know until after the election, even potentially. And an employer will probably be liable, or they will be liable, if they choose to opt in, they have an employee, they defer the taxes, and that employee leaves the company, then the employer would be liable. Now the employer could potentially go after that employee to get money back to pay for it. So I don't know if employers will want to take that employee to collections or go through that process to get that money back. So while it initially doesn't cost the employer anything to do this, it could in the long run, depending on what happens.
Well, that's probably a good question for David too, and just kind of how their systems have been set up. Because David, you're up and running, or I should say Paylocity is up and running as far as managing this, and the employers can log in and set this up if they so choose. Are there any considerations from your perspective as far as, if somebody quits, possibly capturing it from the last check, kind of how you double up on insurance premiums or other things? Or like what was inside your systems calculations?
Yeah, so absolutely, the employer is on the hook should they opt in and should that employee opt in. And you really have to look at it on a case-by-case basis. I mean, you have to look at your turnover ratio and who could potentially take part in this. And if, worst case scenario, if those people were to leave the organization, how are you going to get that money back? And you kind of hit the nail on the head with the doubling up on the premium, because by the way, the $4,000 is assuming a biweekly compensation. So if you are semi-monthly or something like that, just assume like the same sort of hour per dollar attribution for that $4,000. And yeah, that the employers really have to look at, maybe it makes sense for that engineering firm that has I know a personal friend of mine is a computer engineer, had to lower their salary for the remainder of this year. So maybe it would make sense to double up on his premium at the beginning of 2021, because 9/1 through 12/31, that's probably, from a payroll perspective, an equal number of pay periods or close to than it would be on the repay of those deposits. But they do have to. The one thing we do know is they do have to be divvied up. It doesn't have to absolutely be equal, but it cannot be one lump sum on the repayment of those. And if there are any wages, let's see, I could show you my screen, Pete, if that's okay. To share.
You can.
I don't know if it would interrupt the reporting.
No, it's all part of it. Do I have to give you permission to do that? Because that might make our decision for us on whether or not I have the capability of sharing.
Let me try it. Oh, you actually have disabled screen sharing. I cannot. So no worries. There's actually a site, or there's a section on our website that has all of the new press releases, and it actually has what's called micro kits within Paylocity. So if you're a client, where these reports live, how you calculate this in the payroll system, what those earnings and deduction codes look like. So I'm happy to follow up with the guest list to some links. You don't have to necessarily be a client too. A lot of the deduction codes are coded on a generic basis for IRS specs and things like that.
Okay.
I forget what the last part was. So are we set up to calculate them?
Yeah.
Absolutely.
And I got a
I-
question that came in on
Go
the
ahead.
calculation. So it's up to $4,000 biweekly is how it's kind of written out. So is that, let me clarify my question, because I have a question, but I'm having trouble reformatting the question. So if I make $4,001, am I forfeiting the entire, am I disqualified from that, or am I waiving the payroll taxes up to the 4,000?
So it's,
No,
if
you're disqualified, I
you're
believe.
disqualified for that
1,000.
payroll, from what I understand though,
Okay. But
is that it's only for that week that you're above. So if an employee, say they got a bonus in one payroll that took them over that 4,000 in a biweekly period, then they would
Right.
be ineligible on that pay period. But if the next pay period they're only at 2,000, then they would be again eligible to participate.
Okay.
It's not across
If
the
that's fair.
board. It's per payroll.
And I'm assuming the payroll systems, David, are tracking this. Your software systems are able to have that flexibility to turn on, turn off, run reporting on it, have it segregated so we know what we're doing on the repayment side.
Yes.
Because that was
Yep,
a
exactly.
comical conversation we had about 4 weeks ago with Matt. Because we're like, how? I mean, it's one thing to change your income taxes, right? Because in your deferrals, and so your systems already did that. But payroll taxes have been pretty well hard coded for how many years? And so just trying to figure out how the systems, across the United States, we're going to have to retool to accommodate that. So,
And I've been really impressed with our product development team. Not all payroll companies have caught up to speed, but as I look at our, we call them micro kits within Paylocity, and this is just on our public site, but they have sections for each little new update and how you track this and how it's calculated, who's eligible, who's not, and you can do filters within a payroll batch to identify those individuals.
So I
that
know
opt in.
I have one more question for you. Then we're about 4 minutes faster or slower than I wanted to be at, just because I do have some content with Matt. But the burning question, I know the answer for us, but are you aware of any Paylocity client that's actually taking advantage of this deferral?
So we just, like Diana said, we just got the actual guidance, on the 28th. So I personally have not heard of my clients, but we haven't really had any client-facing meetings personally, or on-demand webinars. So I don't really have a good gauge on whether or not clients are taking this. Almost every one of my clients has a PPP, and we're even with moving a client from a provider, we're doing all that tracking and just automatically assuming that we need to get wages, all the way to 2019. But I don't know the percentage that are actually electing for this deferral.
Because I know from our clientele, we don't have one that I've learned that
Nope.
is going to be doing it, have actually made a decision not to do it.
Yeah.
And we're looking at different communication pieces just to make sure that they're communicating with the participant, or I keep on saying the word participants, employees. So the employees are kind of aware of what's going on. And then if anybody read some of the journal reports that came out last weekend, clearly there's not one large organization out there that has decided to take advantage of this executive order because they feel it's going to be much too complicated. And then it's also weighing, is it more pleasurable to have a skipped tax right now, or more painful to have a double up on the taxation in the future if we're not going to have the waiver on it? And I think clearly everybody's kind of been weighing that it's more painful to double up in the future with it. But Matt, do you guys have any clients that have taken advantage of this?
No, we haven't, and we have been recommending really the same as opting out, really because, I mean, there's a business risk, right? As you guys alluded to, the company is on the hook for those payroll taxes if the employee should leave. And it's not waived. So that's really the business risk. Someone has to make the business decision: is will you have unhappy employees if you opt out and then it's waived, then basically people who opted in got $2,000 roughly free, and others who didn't get that. So that's a business decision.
Kind of goes back to our, conversation is how do you make decisions without really all the information that's available, and not available. Actually, we are making decisions with the information that's available. That's a better way of saying it.
Yeah.
And so I don't know how we could be put in a position to, have somebody mad at us.
Yeah.
But
And
I agree with your statement. It's a conversation that leadership has to have internally to see what they prefer to have at their organization.
Yeah, because the only organization that I've heard so far that is doing it is the U.S. government.
Right.
So.